Thank you for listening to the Court of Public Opinion. One of my more important and probably more favorite topics regarding how the Court of Public Opinion separates these issues. We're going to talk about ethics violations because I think a lot of us hear that word used very loosely, and it wasn't till I was in this discovery phase of what exactly an ethics violation is for anyone that has been a victim of a crime, and maybe some cases, depending on what kind of crime is committed, if it exceeds the point of, excessive abuse. It's really, really difficult to divide up these issues because there's a statute of limitations, number one. And number two, it depends on who the victims are and the kind of circumstances. So looking overall about some of the cases involving how to file a complaint or grievance. Now, these are kind of the legalistic things that are going on when you have to look at some of these cases. I try to frame it because obviously a lot of people did not file their cases and they probably never got their case heard. And they live with this, unfortunately, the lack of information. This is kind of the grueling process that some of us have gone through. So you can't hear a case that happened 10 years ago in some cases. Not that that case isn't worth hearing. Unfortunately, if there's no file on it, we're just going to go and it's just going to be based on hearsay and accusations and allegations, and you can't do anything with that. And in all honesty, those cases can't be heard or even tried. I'm learning this as we discover more about this ethics violation, but let's take the example of what I believe today will be a step beyond that. So I did some notes and talking about ethics violations because you could look at different ways to define an ethics violation, but I'm just going to give you a rundown of what I've learned. I'll put some information up here below in the description box, and I'll also post it here shortly. But when somebody makes a statement or a complaint, there's that process. It's usually a 60-day process depending on which state you're in. When it involves a public official, it's usually an investigation, or I'm not quite sure the exact terminology, but if you look at the section codes, which I don't want to repeat, and again, I'm going to put this up here in a moment, but I just want to run through this. So once they go through this process, the investigation, they find out, yes, somebody violated the ethics code, or in this case, it would be a section code. There is a disclaimer because this could destroy somebody's reputation if it's a false accusation. So they have a clause where in good faith, if somebody is trying to help somebody and they're just being accused of something, then it puts things in perspective, meaning there is such a thing as a good Samaritan. And that law, thankfully, for those of you who are well protected under that Good Samaritan law, you're protected because obviously in some cases someone might turn around and sue you. And that's kind of the backward side of it, but most of the time that doesn't happen. Usually someone who acts in good faith to assist, they're doing it in good faith. Okay, so you rarely hear of anyone suing somebody who's acting in good faith. And to me, that would be such a perversion of the law, really. So hopefully we don't ever have to hear something like that. But what we're hearing is when public officials are put in a position where they have to, first of all, you have to meet some of the requirements for the job. And there's a lot of that too. So there's a lot of scrutiny, a lot of vetting that goes into who's going to be running in a position or a job title, or sometimes at a local level, it could be city council. They have to be thoroughly vetted to some degree, or they couldn't be a candidate. But nowadays, it seems like, and I know this is probably what we hear, and I want to just go on good faith, that everyone that applies to hold a public office in good faith, I need to believe that they meet the requirements, and the people that designate them, they're representing all people, not just their particular party, but how would they overall work in the public interest regarding public trust. So when we talk about just a party affiliation, but overall, how would they work with the different parties involved? and we're looking for the best overall candidate, right? And that's typically what people want overall. But we know it's not a perfect system, and in fact, we know it's not, because a lot of times, if you look back, a lot of these cases weren't filed. It's not that they shouldn't be heard. It's just either they weren't filed or people afraid of what they didn't know. On Bible scripture, though, I can say this: for my people are destroyed for lack of knowledge. In some cases, they know something, but they don't proceed. They don't go through the finishing process. Typically, people that don't go and file their cases is based on financial reasons. And that's one of the worst parts of the system. That's why I hope we have representatives aware of that. And they have all these commissions and investigation going on all at once. So we believe in good faith that all the people that are put in those positions are doing it because in good faith they're trying to represent whoever it is they're representing, and overall they have earned the public trust to sit in where they are. It not necessarily doesn't even matter if it's a city council or state or federal. We want in good faith to believe that they're not going to violate ethics, because to me one thing that's breaking the law, deliberately breaking the law, ethics is a lot different because you're looking at a different code. That's what I've learned so far, which is, forgive me, because I'm learning more about this over time. And I think while a lot of cases haven't been heard, and I know that they may not ever be heard, we can close a lot of these cases just based on the fact that the lack of filing, the lack of follow-up, or some other things, or maybe financial reasons. And we could just conclude that most of these cases probably, not that they couldn't have been heard, but they weren't heard and they weren't processed correctly. That, I think, is something that the people need to think twice about, looking back at some of the cases over the last maybe 30 years, the ones at least I'm aware of, they have not gone to court or didn't go to trial, or maybe they agreed. And oftentimes these cases, while they may not have heard, I hope in good faith that people do settle their cases out. Settling out of court is always better. I mean, you should not ever walk away from an agreement knowing that you're the only one that walked away. I think it's wise because it doesn't come back to hurt you. And anyone doesn't have to live with the mistakes of the past. It's always good to maybe even anonymously, even if something wasn't dealt with, I would respect that much more from somebody, because you never know how these things creep back up on you. And if there's an anonymous way to deliberate or maybe kind of work, settle it out of court, that's probably the best answer I have. In good faith, I would have a lot of respect for somebody who closes their cases. To me, it is about closing the deal, but it's not closing the deal per se. It's closing the case and putting it aside. Because right now you have a lot of cases that are now being heard, and I think by today's standards, we haven't reached a level where any of us are at least experienced enough to know exactly how this all plays out in the bigger scheme of things. But you hear a lot of hearings and subcommittees and all these different committees for this, and that's all very good if you follow it closely. And I think when I look to the Heritage Foundation or a lot of the groups that file these Freedom of Information Act, they're looking for particular information. So it is up to us if we want to file for a Freedom of Information Act regarding something. I'm pretty sure I can't say I know the process per se, but it explains a lot of the problems I think we are facing as people that vote. And I was not really into this. I just started doing my homework. So to me, when I do a topic like this, I'm not quite sure we're going to go anywhere with it. It makes sense to do some homework. But ethic violations to me says a lot, because part of the law, at least from what I've learned, is the decisions are made based on a couple points. I'm pretty sure. If I'm not correct, I'll do more homework, but I'm pretty sure a decision is made based on 1, civil law, 2, moral law, and 3, ceremonial law. And I'll put, again, some information below that'll elaborate more on that. Okay, but I think overall that's how a decision and then they write. I believe from that point they write their own opinion. So that's what we're going to do about ethics. I think overall, regarding civil law, one, to settle the matter, because in all honesty, when you both parties agree on a reasonable, fair negotiation, it's closed, and each party has been heard fairly. To me, that offers maybe some closure, and that's oftentimes what most people want, is they want to be heard, number one, and they want closure. They want, in this case, closure meaning settlement, an agreement, and that both parties can live with. That's usually why they call it negotiating an agreement. You know, both parties walk away, the matter's settled, whatever terms of an agreement, how it goes from there. And by today's standards, most divorces now are going through this process. And to me, I think this is the best way to settle a divorce. Instead of going to divorce lawyers and dragging yourselves through court, I see this as working with a mediator and settling your custody issues, family affairs, same thing. I think if you had some problems in the past, my situation was domestic violence, settling this matter, well, two parties walk away and it's settled and you part ways or whatever you agreed to. Moral is the second part of this decision. Because morally, it's the right thing to do, is settle the case quickly. Don't drag it out. Don't drag your family through anymore. A lot of times, especially in divorces, the moral thing is if you're not going to live together and you're not going to live as a family, the moral decision is make your decision quickly, separate the property. Again, that goes back to the whole reason that I agree with the civil part, because that means you can agree to something on conditions that both of you can live with. To me, that goes back to the first part. They kind of work together. On the ceremonial law, to me, regarding how people decide on the law, I'm not quite sure the third part here, but I'm just going to take a guess, and this is based on opinion. If ceremonial law, meaning traditionally how the courts argue these cases, I would just say that overall, when people walk away, they settle all their matters, it frees them up, it allows room for both parties to at some point maybe, just it makes the necessary adjustments, because I think you have to have insight or offer some foresight in this case that you don't want this matter being brought back up. So that's why I agree with the original settlement agreement, because there are a couple parts to it. And when two parties can't agree, it'll ruin, first of all, it'll take all the pain out of the already difficult matter. When there's a separation of property and rights like that, and there has to be legitimate signatures, we know that in good faith, we want to believe that in good faith that the people that were involved in each of these parties, that they did agree and there was a fair agreement settlement. Now, we can leave it there, but the problem I find is that's not always the case. That's the ideal. That's the goal, is to obtain a proper agreement where both parties walk away content. Maybe not happy. I would love to shoot for happy, though. That would be the goal, is happy for both parties to agree to this settlement agreement and they can part ways. Now, mediators cost a lot of money, but when you think in terms of what it costs you and what what you might be preventing down the road, the distress, the anxiety, a lot of times the kids who are in the middle of a difficult separation and divorce, especially if it involves property, inheritance, this takes all the pressure off the children. This takes all the pressure off other family. And of course, a settlement is always important. And in some cases now, what you have is grandparents involved. So there's all types of custody issues. That's why I think it's really important, if there is an agreement that all the parties involved, somebody's representing, maybe even the grandmother, Going to the negotiating table means the attorney is going to negotiate or not the attorney, but the mediator is going to help take this to litigation, and that to me is so much better than families dragging themselves through family court. I mean, you could prevent a lot of unnecessary pain. How does this get paid for? Well, to me, that's something you can't agree with somebody that goes through litigation. Overall, this is what I found, and it was hard because I thought of the ethics part, and I thankfully, the good things about this, because that's painful to go through to try to understand this and comprehend it. My heart's desire is to see that, and this is my opinion, is that people find a way to negotiate, work together, settle the matters, don't drag out 30 years. That's been my experience personally. I'm living through a family divorce, separation, property. It's been personally painful. And everyone that suffered, it was the children that suffered the most, and my family especially. It's really, really unusually difficult to have to live with years of pain when it was dragged out too long. And what I mean by dragged out is that both parties need to settle this quickly and separate the property, or make an agreement that everybody can live with, so that the children and the grandchildren have their inheritance. And a lot of times when people look at the directives and agreements and things like that on paper, again, this is all legalism, but unfortunately, that sometimes people can't make an agreement. It used to be you could just shake your hand and your word was important. I believe when you give somebody your word, I would never want to promise something I know I can't do or overpromise. I think that's kind of difficult today because we're overwhelmed. But there are a lot of people that I've been not arguing, but just kind of discussing and debating on the matters and some of the cases we've discussed, and they bring up a lot of personal difficulties. So my hope is that what we're trying to accomplish here is not to bring up any unnecessary baggage. A lot of times this does stir people up, and that's not the intention. So in good faith, I hope you understand that when we discuss it, it's just because so many people lack the insight or lack information, and myself included. Unless you're really doing the homework, you wouldn't really want to talk about this. But I think why we're talking about it is that so many people have been disenfranchised and they don't know who to turn to. They can't afford an attorney, and a lot of times there is something good about what we are learning, that it would offer somebody a better option instead of suffering unnecessarily, and that is this process of mediating and litigating. I do really think there should be a time where we could come up with smaller panels where they can, on a community level, start helping families or businesses or community leaders, where it's an outside group, a 12-person panel, just random selection, people that, are just average residents, where they can actually help dissolve or maybe diffuse debates. There are things going on today, by today's standard. If you go into someone's neighborhood and you step on somebody's property, on public property is one thing. If you're renting, you have renting agreements, lease agreements. If you have an agreement with a landlord, you have property that it can't, somebody doesn't have the right to just take your property if you're out of area. There are a lot of things damaging somebody's personal property. I mean, it was foolish for all of us to believe that people would not destroy personal property. And this is very damaging, not because of the property, but because of the ethics and because of the principle. And on principle, I can't agree with a lot of the decisions because I see so many problems with why so many people walk away unhappy. And it's usually the people that are on the bad end of the stick. And that's why I think there's going to come a time, maybe soon, where there'll be 12-person panels where they can diffuse even small claims. That is what district court is for. We do agree, but outside of that, people dispute a lot of issues and they know they're not going to resolve it the way they've been going. And the option for people that want to move past it is that you got to get both parties to agree. Unfortunately, in some cases, and in most of the cases, it's hard to get both people to agree. But here's why I think it's really important for that person or that party who isn't not in agreement. You do not know how this might turn out for you. So it's better sometimes to initiate an agreement when you think it's time, but I would reconsider. Because usually when people are willing to agree and they remove their stubborn view of things and they're overcome that stubbornness, most of the time people walk away much happier, satisfied, and they can go on to live better lives. Usually the people that are not willing to agree, they have something deeper going on. And maybe it's not for us to figure out. That way it totally frees up the other person. It's actually very biblical. It's a principle, honestly, that at some point you have to decide you can only do so much. You have to set some limitations. And to me, when you're entrusted with somebody's personal information, you're not going to go use that to hurt them. And then you end up back where we're starting. That's why I really, really hope that both parties always find ways to negotiate and be civil. Listen, that doesn't necessarily mean you walk away that you like the person, you don't. You might have even liked the person or persons involved. Unfortunately, you have to cover your bases. In the world we live in, somebody's always getting, unfortunately, jacked over is the word. I would like to use another word for it, but unfortunately, I noticed that a lot of people do not settle their problems. The best answer to some of this is just settle your problems quickly and fairly, respectfully. I think a lot of these cases can be diffused if we just give people the opportunity to be heard and find out what they want from this, because usually that's the answer most people need. So I want to finish it with a summary, because I got to wrap it up here. Look at all three of these stories, all these cases. I was looking through them. I'm trying to better understand them and do my homework. I can see a big thing common with all these cases. Most of them weren't filed due to, I think some people wanted their case heard, or they didn't know how to approach it. Some of these topics are very sensitive. When we talk about family violence or abuse, that's one of the hardest. Ask any attorney. It's one of the hardest areas of law to argue cases, because there's so much involved, and families, of course, are torn. Again, I think it still applies. If you can learn to communicate, write a letter. Some things can be done better by writing a letter. If you're not comfortable doing that, still write the letter and hold on to it. But a lot of times, I don't think families address their issues. They wait till it gets so out of hand and they let it blow up. And most of the time they can diffuse it, because it end up being something, it may have been a misunderstanding to begin with. So, while taking this high road, some of us can settle our matters quickly, efficiently, and maybe even find somebody to help negotiate. If that's not possible, just try to separate yourself for a time and try to at least find a reasonable solution. Write that letter. Say, right now it's only fair and reasonable that we would just separate for a time and, let things cool off. That way, instead of just dropping the H-bomb on somebody, at least you're giving each other an opportunity to discuss it. I really do think a lot of people have been burned, and I don't want to see that keep happening. So it's always easier. Just separate yourself for a moment. Give each other some space. Most of the time, that's usually what people need, is they need their space to be them and enjoy their hobbies. A lot of things we emphasize too much on cases, and it takes away from the fun of living. So this is another step in that recovery process, because a lot of people should be able to walk away happy and be able to be content in doing the things they need to do to live somewhat successfully. And as long as there's realistic goals and people can walk away and do their thing without fear of retribution, usually by settling those cases, that matter will be settled, and I can know and be reassured confidently that both these parties agree. And if people are walking away unhappy, most of the time it will come back. That's why I would encourage people to settle the matters. We laid out the case for 3 different reasons why some of these decisions are made. Of course, I didn't get into all the details, but anything I did not elaborate on, I will put it below if I find it, and I will put some information that will help people kind of negotiate and come up with reasonable answers that people can live with, especially at home. Even debating when it comes to politics, that's one of the most divisive topics nowadays. And especially it's separating families. And we hope that people would find ways to resolve their conflict, that they could respectfully disagree, but enjoy the opportunity to have an intellectual debate instead of making it an emotional debate. This is emotional intelligence. When we look at these topics, I can see people will walk away, maybe not happy, but satisfied with that answer and solution. Thank you. In some cases, when we deal with kids or people that are younger who don't understand, it's the way you communicate it and restrict it, but restrict it with the understanding that yes, you can earn back your freedoms a little bit, like privileges in this case. Not freedom so much, because you still have freedom. That's the idea. But a lot of times I think what is going on today is that people have great expectations and they get discouraged. And that's due to lack of communication, or maybe it's in some cases people aren't explaining it correctly, and I would go about it sensitively. A lot of people don't understand all the issues we are confronting to the degree. That's why it's better to do your homework and know what you're talking about before you even talk about it. That's why I'm stating there's some things I can't comment on because I don't know the extent of it. I have a better understanding of it, but I don't have a specific answer for some things on some topics. Like, I'm starting to better understand the gender issue. I didn't understand it, but I'm better understanding. Thank you for listening to the Court of Public Opinion. This Court of Public Opinion session is in recess. Have a great summer. It's nice to have some recess and some time off, so we look forward to doing some broadcasts at the Moonlight Lounge. You'll want to stay tuned for our special episode, July 7th, 2017. Have a great summer.